This time, the court will call cause number CVW 160. The court had this matter set for a services review hearing last week. There were a number of issues that needed to be addressed, and it was recessed and continued to today. So we're set for a services review hearing today as well. The department is present through Ms. Christy Dare with Belong and Mr. Lopez with CPS. Ms. Leslie Levi is the attorney representing CPS, and she is joining now. And Mr. Michael Finkel is here, and he is the attorney for Austin. So let me swear you in, Ms. Dare and Ms. Lopez. If I can get the two of you to raise your right hand. Do you swear and affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Ready. Yes, ma'am.
All right, thank you. Before we hear from you directly, is there anything, Ms. Levi, that you want to address with the court before we get started with their testimony?
Yes, Judge. It may be easier for me to just put it on by stipulation, and then we can ask the witnesses if they have any other information.
Okay.
So after much digging, it was discovered that the court was given not fully incorrect information, but also not fully accurate information. So the previous caseworker had been in touch with the Travis County Probate Court, and the probate court initiated a guardianship proceeding. However, the probate court had been under the impression that a guardianship proceeding would be or had been initiated in Wilson County by either the mother or I believe by the mother. So they told us that, having been told that, they could not proceed with a case having already been started. So I called the Wilson County clerk and the Wilson County district clerk, and they both assured me that no proceedings had been started in the interest of Austin. So I called the Travis County probate court back, and they said that if that was the case, they could move forward with instigating that proceeding. In Travis County, there is a nonprofit known as Family Elder Care, which can serve as the guardian of the person for people who do not have relatives. They do have to notify the mother, and I believe Austin has a brother, in order to move forward with that proceeding. However, the caseworker informed me that he has tried the mother's numbers and has not been able to reach her. So they have to go through their due diligence and get that done, but they are willing to move forward. I will be upfront with the court. It looks like a lot of balls were dropped up until this point. Typically, the way DFPS handles these situations is to make a referral to HHSC, and HHSC starts a guardianship proceeding. By policy, that referral should have been done by the time Austin was 17. So we are many, many years late. Belong did not have the original documents that they would need to complete that referral to HHSC. They have since found the documents necessary. However, we fully expect that HHSC will deny the application as untimely. So it seems like our best bet is through the Travis County Probate Court. I received an email back from her. We were going back and forth about, was there a Wilson County case? What had happened? I received an email back from her yesterday that they would be able to move forward if there was not a case in another county. I told her, to the best of my due diligence, I could not find one. However, I did not think to ask, and I should have, the time frame on that process, because I know that we lose jurisdiction in about a month and a half. If the court wants to set a review hearing next month, I will follow up personally with the probate court to see where we are. In the alternative, I believe there has been a document that I'm not familiar with that Ms. Lopez can probably speak to allow the placement to have some more leeway in making decisions for Austin. It's kind of a It's not the ideal document in this situation. Obviously, a guardianship of the person would be more thorough, would be better, but it is kind of the, barring Travis County going through their due diligence, the best we can do at this point.
All right. Do you know where they were under the impression that a guardianship was being filed in Wilson County? Because that's never been represented to me at any stage of this process. Ms. Dare, you said you think you know?
While I don't know about the Wilson County, what we were informed was the Travis County case initiated because the current caregiver, Mark Hansen, applied for guardianship privately, which is the preferred first method of seeking guardianship. An investigator through probate court was assigned to him, and it was determined that it was a conflict for him to be named the guardian because he had been being paid as a caregiver for Austin. And so that they dropped that, and Mr. Hansen decided that he could not afford to continue to pursue that. At that time when it occurred, what should have happened was the dad's guardianship should have began. I do not know where the Wilson County came from, because in everything that I have read, Judge, it is always indicated that mom would not be able to be a guardian for Austin. So I do not know where that piece came from. The dad's guardianship, it was not initiated until Pedro received the case. And while we are still working on it, because we still do not have the complete documents, it will likely, like Ms. Levi said, it will likely be denied because it is not requested timely. Additionally, his current DID that we received actually is not current at all. And so had it been requested timely back when he was 17, it would have been appropriate. But since he's been in an HCS home, in the eyes of dads, he is technically no longer in care. And that is partly why they will deny it, because it has to be completed while he is still considered in care. But since he was in an HCS, it's my understanding that he is not technically considered in care at this point. So we are still continuing to go through the process, even though we know it'll likely be denied. We're still going to continue doing that. Additionally, as was indicated, we have followed through with the third option. As in these type of cases, there are the three options, and that is the supportive decision maker. That is a form that has been signed by Mr. Hansen, and it has been notarized, and it does give him the ability to make all necessary decisions to ensure Austin's continued well-being, such as medical, food, clothing, shelter, any kind of therapeutic services, things like that. It does continue to allow for.
But it basically is setting up an arrangement that the probate court in Austin thought was not appropriate for a guardianship, and it's an end run around that, right? Like, so there's been an assessment of there's a potential conflict of interest even in that arrangement, is there not?
I believe, I think that that's possible. I do think that the supportive decision maker is a little more limited, so I think there's a little bit less room for abuse. Additionally, I think if the guardianship goes through, it will likely override that supportive decision maker. And as to your previous question about where the Wilson County allegations came from, The investigator that I talked to had emails in her file, I think from a previous DFPS attorney saying that the mother was going to file. I have no idea where that idea was given to them from, because, you know, as Pedro told me, they have not been able to reach her at all on any of her previous numbers. So I don't know where that idea came from. I don't know which, you know, like I said, I called both clerks just to make sure, and I could find no evidence of an existing case. And I did relay that to the Travis County Probate Court, and they said they would move forward.
Well, and I could tell you there's no Wilson County case. That's never been discussed at any prior proceeding. And it's just very, very upsetting to me, because I don't know what else I could be doing differently. I rely on the representations of the department, and it seems to me the previous worker was not being 100% truthful. But I also see just across the board, because this is the second case in the past year in which things have not been done for seriously disabled children in extended care with the department. And to the extent that one child did not have Social Security, adult Social Security set up. And I don't know how to verify from my end if I'm being told everything's in place. Ms. Lopez, are you a disability specialist with the department?
Yes, ma'am. I'm one of the 3 Region 8 ones.
All right. I mean, am I going to need to mandate that a disability specialist be present at every placement review and services review hearing leading up to a child's 18th birthday? Because I'm being told things that are patently not true. And I don't know how to verify that they are if people aren't representing things correctly to this court. And you would be the person that could speak to that, could you not? If I'm dealing with someone with a severe developmental disability?
Yes, ma'am. We're working with Belong to kind of go back and relook at a lot of these cases that were in the rural that are currently like this. And, you know, unfortunately on this case as well, the previous worker, I had no idea was coming to court and testifying to this information. But yes, you can request, if you want to, we can email updates prior to court if that would help, if you would like that.
Well, I just need to know that we're doing what we need to do. And you know, when I have someone in court, usually if they're under oath, there's a certain amount of trust that I place in the testimony that they're providing. But it seems to me that this is the second time. I mean, Austin's been in this placement since well before his 18th birthday. So this idea that he's no longer in care just because of this HCS placement is kind of absurd to me, but I don't control and, you know, I'm not well-versed in the processes of dads and in the adult guardianship proceedings. It's beyond me, but this, it seems to me we have a major issue here that, you know, is placing Austin at risk, and that I feel responsible for, but I don't know what I could have done differently. Mr. Finkel, I mean, I know that at previous hearings, you represented to me that you were also in touch with the individual and the investigator in Austin. I mean, did you have any idea that they were under the impression a guardianship was being filed in Wilson County?
Not specifically, Your Honor. The only thing I can think of is that I know they were aware that the mother was supposedly a potential applicant, unless they just assumed that she would file it in Wilson County because that's her residence. But other than that, I don't know why they would think that.
But
And
the
then-
problem
and
there,
then the
now
same
that,
goes to the court.
I mean, I guess the issue, I'm just trying to understand this, is that the private guardianship filed by Mr. Hansen, when that was unsuccessful, that was the end of their inquiry there in Austin. Is that what I'm hearing?
Your Honor, that's not what was
That is
represented
my
to me.
understanding.
That was not what was represented to me. They said that they did determine it was a conflict of interest, but that since the proceedings had been started, they were going to continue them until they thought there was another case already filed. That was the impression I got from speaking with the investigator. Obviously, I wasn't around this case at that time, so I can't speak from personal experience. And this, my understanding is that this attorney with the probate court is also new, so she was just going off the emails in her file. But her understanding was that they stopped moving forward based on the idea that there was another case in a different county.
And that's what I'm saying is when they heard, whether it be from the caseworker or whoever, that the mother might be an applicant, they stopped doing whatever it is that they were doing as far as investigation or as far as appointing a private guardian. They I guess put things on hold, thinking that the mother was going to do something.
Instead of investigating themselves as to whether or not she would be a viable option, which I was led to believe was the next step of their inquiry.
Correct. If she was going to do it through Travis County.
Right.
And I guess if she never contacted Travis County Court trying to pursue it, they might have just assumed that she was doing it somewhere else. I don't know, as far as I can't speak to what they were thinking.
So, Ms. Dare, the dad's referral, you've indicated you don't even have an updated and current DID diagnosis to submit. Is that what you're representing? So, I mean, the likelihood that you'll even have an application that dads can reject it seems very unlikely to me if you don't have all the necessary materials.
So right now, Judge, in speaking with Sarah and in our staffing, and up to this point, I hadn't dealt with dads ever in my tenure, but up to this point, what has been decided is we're waiting on a current psychological, and we are going to submit that along with the DID that we do have as a part of the application to dads. And then we will move forward from there.
All right.
And so we are working to get, we've been working diligently to get everything that we needed. There were some setbacks when we got assigned this case and once we learned that this had occurred. But we have been working to get that done, and we are going to have something to submit. Yes, ma'am. I think, if I'm not mistaken, though, he turns 22 in 3 weeks, I believe, not a month.
It's March 8th.
Yeah.
Right, but I believe we can keep the case open through the end of March, was my reading of the code. Unless I'm mistaken.
Well, I'm speaking for submitting the application.
I see.
It has to be submitted prior to March 8th. And
I
so
see.
we are working diligently to get that done and completed. Sarah, myself, Pedro, as well as other individuals from Belong have been working to get everything we need to get that done. And like Ms. Lopez said, Judge, we are going, especially after what has occurred here with this youth, we are going to be looking at all of the cases of children with disabilities to ensure that we are doing things correctly from this point forward. I don't have, I mean, unfortunately, I only had what I was provided to go off of in this case, but it is something that we are taking very seriously and working to ensure it does not happen again in the future.
Well, I certainly appreciate that. And from now on, I will need to require that a disability specialist be at every permanency review after final order and every services review hearing involving a child with a DID diagnosis. In the event I've had, this is a gross violation of Austin's rights. And it's not fair right now to hold Belong accountable for what the department failed to do previously. And I understand that, but the department failed this child and failed in its, and this process failed because this court is only capable of making findings if the information that's relayed to this court is accurate, and it clearly was not. So I've learned a valuable lesson here as well, that that CPS workers are not well versed in this process. And so it's not a matter of, you know, it is a training process for anyone who's got this type of case, but it's also, I mean, from this point forward, the disability specialist needs to be an active participant in court. And I would say not just in this jurisdiction, it should be a policy at every in every jurisdiction that Belong goes to, because it just boggles the mind about how misled this court was for years. And I don't know what else I can do independently on my own when all we have is a services review, and I'm reviewing whether or not the services that are being provided are adequate. What else I can rely on? I'm very disappointed and upset, and I think that at this point, the court will be setting weekly services review hearings so that I can get updates, and I need everyone who's here now to be there for those other hearings. I want it known in the application for the dad's guardianship. There needs to be a very clear, you know, I think admission that there was a failure to do what was needed to be done, but that's not fair to Austin, that be a basis to deny him a guardianship if that's what's ultimately necessary. And then you have the option for the Travis County probate proceeding to go forward. That obviously needs to happen as well. And it seems to me we need to do everything we can to avoid just a piece of paper that allows a supported decision maker. That is not the ideal situation for Austin, and is the least protective of him and his needs going forward. And he has extensive needs, and he needs to have someone who is legally responsible and held to a fiduciary duty in making decisions on his behalf. So I would like to come back.
It is by Zoom, so I could do later in the day, but I cannot do 9. I can reach out and see if another attorney is available.
I mean, another attorney is not going to, that's part of the problem here, is that it's obvious to me that the attorneys for the department don't know this area of the law either.
Yes,
I mean,
ma'am.
I don't want another person coming in who's just taking notes and can't contribute anything and doesn't have that personal information.
And Your Honor, just so that you're aware, I have set this one up the flagpole since mistakes were made. So I will say the managing attorney for this region is aware of this case. I staffed it with them. because I didn't want this to go unknown. So it wouldn't be a totally new person. But if the court is available in the afternoon, I'm certain I would be out of that hearing.
I could set it at 2:30 that afternoon.
I am available.
I'm available.
I'm available.
All right. So we will be back at 2:30 on Wednesday, the 22nd. And you can provide me the update as to each of the dad's application, the ongoing Travis County probate proceeding, the third option as the supported decision maker, which I don't like. So we need to be actively pursuing the other two. So anything else that we need to address at this time? All right, well then I will see you all back at 2:30 on the 22nd.
Thank you,
Parties
Judge.
are excused, thank you.